Hi friends, today we are going to learn doctrine of factum vallet. When we studied the sources of Hindu law, I said there the sources of Hindu law can be classified into ancient sources and modern sources. Ancient sources of Hindu law include Shruti, Smritis, customs or Sadacharas, commentaries and digests, and doctrine of factum vallet. There, I didn't explain what is doctrine of factum vallet because we need to study it in a little bit detail. So let's see what is doctrine of factum vallet. It is a Latin maxim which means what ought not to be done if done is valid. That means ചെയ്യാൻ പാടില്ലാത്തത് ഒരു പക്ഷേ ചെയ്താൽ സാധുവാണ്. What ought not to be done if done is valid. ചെയ്യാൻ പാടില്ലാത്തതാണ് ബട്ട് ചെയ്തു പോയി, അതുകൊണ്ട് അത് അസാധുവാക്കപ്പെടുകയില്ല. It is valid. This doctrine of factum vallet is used to cure the irregularities of a Hindu marriage. A marriage needs certain formalities to be fulfilled for making it valid. ചില ഫോർമാലിറ്റീസ് ഫുൾഫിൽ ചെയ്താൽ മാത്രമേ ഒരു മാരേജ് വാലിഡ് ആവുകയുള്ളൂ. If the formalities are directory or recommendatory, then the doctrine can be invoked to cure the irregularity. But if the condition or formality is mandatory, then the doctrine cannot be invoked. അത്തരത്തിൽ ഒരു മാരേജിനുള്ള ഫോർമാലിറ്റീസ് ആർ ഡയറക്ടറി ഓർ റെക്കമെൻഡേറ്ററി, അത് ടെക്സ്റ്റുകളിൽ പ്രതിപാദിച്ചിരിക്കുന്നതോ അല്ലെങ്കിൽ ശുപാർശ ചെയ്യപ്പെട്ടിട്ടുള്ളതോ മാത്രം ആണെങ്കിൽ, then in order to correct the irregularity of a marriage, we can invoke this doctrine and we can correct the irregularity. But if the condition or formality is mandatory, mandatory means നിർബന്ധമായിട്ടുള്ളത്. So if the condition or formality is mandatory, then the doctrine cannot be invoked. എപ്പോഴാണോ അത്തരത്തിലുള്ള ഒരു കണ്ടീഷൻ മാൻഡേറ്ററി ആയിട്ടുള്ളത്, നിർബന്ധമായിട്ടുമുള്ളത്, then we cannot apply this doctrine and we cannot correct the irregularity of that marriage. For example, the consent of the guardian in a marriage is only a recommendatory condition. Hence, the violation of this condition can be cured by applying the doctrine. But the irregularities arising from sapinda relationship, prohibited relationship and bigamy are mandatory. So, violations of these conditions cannot be cured by applying the doctrine. ഒരു മാര്യേജിലെ കൺസെന്റ് ഓഫ് ദ ഗാർഡിയൻ ഈസ് എ റെക്കമെൻഡേറ്ററി കണ്ടീഷൻ, ശുപാർശ ചെയ്യപ്പെട്ടിട്ടുള്ള ഒരു കാര്യമാണ്. അത് നല്ലതാണ് ഉണ്ട് എന്നുണ്ടെങ്കിൽ, സപ്പോസ് ഇഫ് ദർ ഈസ് an irregularity, consent of the guardian is not there, then also the marriage is valid. But if there is a marriage happens between sapinda relationship, prohibited relationship and bigamy, then we cannot correct that irregularity using this doctrine, because these conditions, sapinda relationship, prohibited relationship, bigamy, these are mandatory. They are not recommendatory, they are mandatory, they are essential, nirbandhamana. So, if there is an irregularity happens in a marriage because of the violations of these conditions, that cannot be cured by applying the doctrine of factum vallet. The marriage is invalid. For the sapinda relationship and prohibited relationship, there are exceptions also. Not to make a Hindu marriage valid, the parties should not be within the degrees of prohibited relationship. However, if custom or usage permits such relationship, then such marriage is valid. Otherwise, the marriage becomes void. For example, in Tamil Nadu, a brother may marry his sister's daughter. Similarly, the parties to the marriage should not be sapindas of each other. There also, if custom permits such marriage between sapindas, valid. Otherwise, such a marriage becomes void. Now let's discuss two case laws also. Ashok Kumar versus Jayendranath. In this case, a Hindu marriage was performed within the prohibited degree and the court held that the prohibited degree was a mandatory rule and hence its violation would not be cured by applying the doctrine. The marriage was held void. Number 2, Ganesh Prasad versus Damayanti. In this case, the marriage was performed under the Special Marriage Act. The bride was minor. The consent of the guardian was not obtained before the marriage. The court held that the marriage was valid as the consent of the guardian to the marriage was only recommendatory.